I want to thank the Freedom Law School for inviting me out and let me tell my little scenario, my little story. My name is Whitey Harrell, and I'm from Central Illinois, near the capital of Illinois, Springfield. And May of 2000, 24th, 25th, 26th, I went to trial, charged by a grand jury of willful failure to file Illinois income tax return forms for the years 92, 93, 94, 95. In Illinois, this is a felony charge. It's a little more serious than, say, on the federal level, which is misdemeanors. So, you know, well, I became scared and I took it quite serious. So, I had a 12-person jury, and after a 3-day hassling in court, they went into deliberations, and after about 3 hours, they came back that they not guilty, not guilty, not guilty, not guilty. And believe me, I was a happy, happy man. The trial took place in a town called Lincoln, Illinois, and it was named after a very famous man. It was named after Abe Lincoln. He christened the town by breaking watermelons over the rail fence around the town, and proclaimed the town to be called Lincoln. I guess he used watermelons because evidently champagne wasn't very popular at that time. I don't know. During the trial and the closing arguments, since we were in the town of Lincoln, we kind of like to tie something together to show my intent, and we likened it to something that Lincoln did during his time of the Civil War. He was president during the majority of that term during the Civil War, and he had a commander that he wasn't very happy with, and Mr. Lincoln wrote him a letter. And he evidently criticized him very severely in this letter. But thinking about it, I guess later on, he maybe thought it was too severe. But anyway, he did not mail that letter. He wrote the letter, but he never did mail it. They later found it in his belongings in his desk. And we used that to show a likening to my case, that they said I was required to do something. I did that. In other words, I wrote a letter. In other words, I filled out a form. I simply never did send it. I never did mail it. I didn't give it to anyone, so I wasn't required to do that. And the likening of this is the issue that we try to put across to the jury is that the statute says you are to make a return. It doesn't say anything about filing the return. Now, one of the issues that the government has to show, prosecutor has to show, to have a state liability, they first have to show that you have a federal liability. And to do that, they use a formula. And that formula comes out of a thing called a U.S. Master's Tax Guide. Well, that's what they had done in my case. They brought forth the numbers that Mr. Harrell made a certain amount of money, and according to this formula, he was then thus required to make a federal return. Thus, he was required to make a state return. Well, folks, I want to tell you something. The U.S. Master's Tax Guide is not law. This was argued during the course of the trial, and the state of Illinois finally conceded that yes, it isn't law. There they was in a court of law trying to use the statute to show that I was required to do something, but they was using that formula, these numbers that comes from a book that isn't published by Congress, wasn't created by Congress. It's a private book. So in their closing arguments, we never said that the U.S. Master's Tax Guide was the law. It's just a guide. Did you hear that? It's just a guide. It is reference material that helps individuals file their taxes. It helps not only individuals, it helps corporations and other agencies. The numbers that came out for the years 92 through 95, now these numbers, they didn't come from thin air. There has to be some information for the people to know when they have to file those forms. Again, it's just a guide. So I'm just pointing some things that came about and that we learned during my trial that you might be aware of to use in any of your events that might come your way. That they can't really prove up that you had any obligation to file because they have no numbers to show that, no lawful numbers to show that there is a requirement upon you. During the course of their investigation upon me, they showed up at work one afternoon as I came in off of the mail route. By surprise, they confronted me as I got out of my vehicle. Said they would like to talk to me about my tax obligations. I said, well, I don't know that I have any, but I don't want to talk to you today. Well, why not? We just had a few questions for you, and I said, well, I stand here naked for, you've got a witness here, and I have nobody. Now, I've got no problem about talking with you. I'm just going to do it at a more convenient time. So we agreed to, whenever I got ready, could set up the time and schedule anything to let them know they'd be glad to meet with me, which about 3 weeks later I did. I informed them that I was going to tape the proceedings, tape the hearing, tape the gathering, and they had no problem with that. And if you're going to, you've got to inform them of that, give them an opportunity to do the same. And what I didn't do was just tell them that I was going to videotape. But we gathered, my witnesses showed up, and we already had the video set up whenever they arrived, and they didn't object, didn't say a word about it. And we sat for about 40-45 minutes. Had a big long table, those two people on that side, me over here, and I was presenting to them all the time documents from the administrative code. And I kept asking them for the law to show me within the administrative code, which an agency is the one that has to enforce. They write the rules and the regulations for the function of the agency. And I kept presenting the documents to them out of the administrative code and saying, I can't find me in there. Would you show where I'm named or shown within these administrative rules? And they never did. And they kept, one of the agents kept trying to write down the questions I had. He said, you know, I want to make sure that I've got your questions right. Now, what is the question? What is it you want to know? And he would make that attempt to, what I thought at the time, he was probably writing down. You want to know, da-da, and find, where can I find, da-da. And he'd done this several times. He said, I want to make sure that I've got the question right so I can get an answer to you. And then again, this picked up on that video, which was a great piece of evidence. Well, how he got back to me was with a grand jury indictment. What he didn't tell me at the time, and what I didn't know, that he was there working for the grand jury. He had already testified to a grand jury, and what they had done was sent him out to do an investigation for the grand jury. He identified himself as being there in behalf of the Illinois Department of Revenue. In fact, he was there in behalf of the grand jury. So whenever he told me that he was going to get back to me, what he done was he went back to the grand jury. He testified as to a meeting with and the things that he had learned. He just never did tell them about all of this paperwork that I gave him, all the questions that I asked. So at trial, naturally, the state brought him in as one of the witnesses, and we got to examine him. But you know, he became very forgetful. He just couldn't remember answers to, well, when you met with Mr. Harrell, did he ask you any questions? Well, I'm not sure. He may have. But he just typically became very forgetful. Well, later on, we were able to show that tape recording to that grand jury. And it really brought out the kind of character this guy was. How he lied. I can't use that harsh word. You know, how he rearranged the truth. Because whenever, you know, he was expected to answer truthfully, that's when his memory became foggy. I can't remember, I don't know, I'm not sure. But it sure did, that video sure did paint a very good picture to the jury as to what kind of character. He really knew, he really understood. You know, whether he forgot that this video was made, I don't know. But anyway, it really became very, very helpful, in my case, to show bad faith from prosecution. In Illinois, the statutes reads dealing with taxation. There is a tax imposed, measured by net income. It is hereby imposed on every individual, every corporation, every trust, every estate, for whatever particular tax year is involved. It is imposed on the privilege of earning or receiving income. Now the key to all that gobbledygook right there is a tax imposed on some kind of an act. It's imposed upon a privilege. So that was my key issue I kept trying to find out what privilege that I was engaged in that required me to do the things they claimed that I was required to do. You see, the reason that word is there, privilege, is because the tax is imposed upon the activity, it is imposed upon the event that you're involved with. And that event is called commerce. To be engaged in commerce in a state, in other words, selling something, for example, you go to the state, the sovereign, and you ask for the privilege of doing it. In other words, I'd like to sell gasoline in the state of Illinois. I go register with the state, and they grant me the privilege. They grant me a tax number. They grant me a whole bunch of things. I fill out forms, give them a lot of information, and I agree to be a tax collector for them. You then become privileged. That's why that word is there. I'm just pointing out to you that you might want to look at your state code statutes and send away, and there's a particular word that you need to find. The tax is not imposed upon everyone out here. It's just, it comes from the sovereign. And they give you the right or the privilege to go out and do something within their state. And if you become a tax collector, if you become a privileged person, an individual, a corporation, and you collect something in behalf or in the name of the state, you better return it. That's where the requirement of making report, of making returns. That's why you're required to do those things. We focused heavily on that word and on that term during my trial. I think the jury picked up on it. Those words and the discussion that we had at the hearing focused on privilege. So, to keep this in mind, I'd like to pass on to you a very simple, easy way to create a reliance defense. During the course of my trial, one of the things that came out is that they brought in a lady from the Illinois Department of Revenue and asked her whether she searched the files to see whether or not that Mr. Harrell had filed any forms. She testified that no, she could not locate it. The other question that came about, did he file an extension time? If he didn't file the form, did he request more time? And no, she could not find any record of doing that. And that stuck in my mind for a long time. Why would that be so important? Well, the courts have said that if you're going to assert your constitutional rights, you have to assert them at your earliest event, earliest time. And I come to the conclusion that what better time to assert my constitutional right would be at the time of filing. There is a Supreme Court case at Garner versus U.S. where the Supreme Court said that the information that you reveal in the preparation and the filing of an income tax return is for the purpose of the Fifth Amendment, the testimony of a witness. Well, I've become very understanding about testimony and about being a witness because I sat on a witness stand. So I thought to myself, well, why not assert my constitutional right right at April 15th? So I began to ask for an extension of time. Since they said I was required to file something, I have been doing that. I filed an extension of time. The purpose of doing this, I'm setting up a reliance defense, something that I can testify to should they ever put me in a criminal situation again. I can sit on a witness stand and I can tell 12 people a very simple story about my beliefs and my rights that they're going to pick up on and understand real easy. Because if you raise many issues, it tends to confuse the jury. Now, on the federal level, on the instruction sheets, you're right as a taxpayer. And it tells you, over here at the side, it says, the is to provide America's taxpayers top quality service by helping them understand. Very key words. Well, helping you, so if you're going to get help, you've got to ask for help. So I do this on the state level and on the federal level. I simply take a 4868. This is an application for an automatic extension of time. And I've got some sample examples, so you don't need to be writing a bunch of stuff down. After speaking here, I'll pass out to you some samples. But I use a 4868. And this extension automatically is just, if you file it, it automatically takes you down to August. In August, you got, if you haven't filed or they haven't helped you, you've got to file another one. I'll get into that. But on the back of this little form, I request an automatic 4-month extension of time to August the 15th to make, to sign, to file an income tax return for the calendar year 2000, or until the Internal Revenue Service can or will show me how to make, to sign, and to file an income tax form without waiving, abandoning, relinquishing any of my constitutional rights, specifically the Fifth Amendment right not to be a witness against myself, civilly or criminally. Will you help me? Can I expect assistance? So now I follow their request, their mission. And I've asked for help. Now, do you think that anybody will ever show me, will ever be able to show me how to violate my rights? No, they won't. But again, the purpose of this is not to make them go away. It's to set up something that I got to talk to a jury of 12 people about my right. The reason that I believe, this is my belief, this is my knowledge. The Supreme Court has said that if you write down and send in to somebody, you become a witness. So again, this takes me down to August. And in August, since no one has helped me, I simply ask for more time. I'm making a record. This record, should they ever put me in a criminal situation again, can be brought into a court and shown to the court that, shown to a jury, that he attempted to do something, he wanted to do something, he tried to do something, he asked for help, but they never have help. But in August, then I send in another request and I provide the same information. They say, you have to provide a good reason for us to give you another extension. And I simply tell them that I have not received help from my first request and I need more time until they can show me or help me. Again, this is a record. And basically what you're doing is continuing to follow through to say, hey, show me the law. Show me how I'm one that's required to do this. Show how it applies to me. Show me the classification that I'm in. That you're always looking for the law. This was a theme in my trial. And evidently the jury picked up on that Mr. Harrell continued to look for something that they never did provide any information for. Now, during the course of the trial, the jury saw this evidence go into the record. In other words, whenever I testified and I talked about some of the stuff that I gave Mr. Craner, the special agent, this was accepted and was filed into the court record. Well, the state didn't object to that. The next day, you do what you call house cleaning chores and so the jury wasn't there, and before the jury is brought in, why the state comes in and says, we need to object to this, argue about some issues. So they objected to the information that was put into the court record. And naturally, the judge and the prosecutor, believe me, they work together. They work hand in hand. They wanted all of that stuff stricken from the file, and the court granted that. So that stuff was removed from the file, but the jury never did see that. They never heard anything about this information, this documentation being removed. Whenever they went into deliberations, remember, the judge tells them, says, I will read you the instructions. I will instruct you to the law. He never says, I'll give you the law. What he does is he writes out instructions. He provides instructions to the jury as to what he believes the law is and how it applies. They are to take that and to use his instructions to surmise from the evidence as to where it fits and whether or not you're guilty or innocent. Well, when they went into deliberations, they couldn't find some of this documentation that was provided in open court in front of their eyes. So they sent out a note to the judge. We would like to see the defense exhibits, including all the documents given by Mr. Harrell to Agent Craner. They didn't have them. They couldn't find them. So they sent this note out. Well, when that happens, both parties, the prosecutor brought into court, the defendant is brought into court. This note is read. Each party has an opportunity to argue. The state says, no, we don't want that documentation going in. We've already argued this. The court has agreed with this, and we don't believe it should. And of course, the defendant says, well, it's part of the trial. It was already entered into evidence. This should be part of the record. They should have that now. Most certainly they should get it. But the court says, well, I agree with prosecution. We're not going to give it to them. And so he writes up this little note. The court has received your request for documents given to Agent Kramer. These documents are not being provided to you. You have been instructed as to the law, and you must apply the law as I have given. You must apply the law as given to the facts in this case at arriving at your verdict. Well, whenever they got that back, later on, as I had an opportunity to talk to the jury, man, they told me, that really put doubts in our mind. That began us to wonder why, at one time, when all this evidence was in the courtroom, why aren't we allowed to see that? Why aren't we allowed to have it? I guess that began to sway some of the other jury's mind, because there was a few of them saying, yeah, well, if the judge told us that's a law, he must be right. Their minds slowly began to change. I guess they deliberated another hour, and they sent out another note. And again, these are just actual copies of what was written by the jury and sent out. Because evidently they began to discuss about the U.S. Master's Tax Guide and how relevant it was to the case. Because they said, we would like the numbers of the law which reflects the criteria that a married person filing jointly under the age 65 is required to file a federal income tax return when the gross amount is ... In other words, this U.S. Master Tax Guide has a formula, has numbers in there, and if you make up to a certain amount, you're not required to do anything. If you go over that amount, you're required to file a claim. We also would like a copy of the Chapter 35, Section 5/502, 50508, and 51301. Now these were the numbers that were in the indictment. Evidently, those statutes didn't go back to the jury deliberations either. Well, we were called in, given the opportunity to argue, do they get them or do they not? The court says, well, I agree with the prosecution. They don't get them. He sent his note. The court has received your request. You have been instructed as to the law, and you must rely upon the written instructions as given to you in arriving at your verdict. Well, whenever they got that note back, that was pretty well cinched my case, because they indicated to me that it really upset them, that the judge would not honor their request and give them all of the evidence of the records for them to make up their mind. And shortly after that, they came back in with the not guilty verdicts. Well, when that judge had to read those 4 different times, every time it seemed like he got a little redder. And when he was through, he asked the prosecution, do you want me to poll the jury? The prosecution said, not requested. And he simply got up off of his big tall bench and flew out of the courtroom with his little black robe. He didn't turn to his jury and say, I thank you for your time. He didn't speak, he didn't say nothing to them. So it fairly well upset him also. Well, being very elated, I turned to the jury and said, thank you. And that jury gave me a thumbs up. Thumbs up for a like this. And as they filed out of that jury room, they had to pass my defense table. And again, with tears in my eyes, I was thanking them as they passed by. They extended their hand I didn't reach out to do nothing, but they reached to me to shake my hand. Mr. Harrell. Mr. Harrell. So, when it was all over with, and the jury foreman, who happened to be a guard at one of the penal institutions in Logan County, he delivered his paperwork to the clerk's office, and as he left the courtroom, he went across the street to where my attorney was parked, and he said, "You spoke for Mr. Harrell, and you've done a very good job. Do you have a business card? I may need you in the future." So I take from that maybe I planted a seed. Maybe the whole event, he planted a seed. So I guess what I need to relate to you is, whatever defense you're going to use, make it simple, make it easy. Do not use a lot of theories, because juries seem to get confused on those. And if you create you a reliance defense, you will have something already prepared, simply, that you can talk to a jury about. Because the jury explained to me that I was a credible witness. They believed what I said. They felt that I was sincere in my beliefs and what I was doing. So, you can't get up and do a lot of stumbling around, or I think, and I believe, and I hope kind of answers to witnessing. Now, at the time that the trial was going on, I kept, and the people who was with me there, kept looking around for the news media. Usually when a tax trial was going on, there wasn't anybody there. And so one of the people that was in my crew a couple of days after contacted the newspaper and said there was nothing reported about the tax trial that took place where a man was found not guilty. And they said, "Well, we didn't know about it. The newspaper office is just across the street from the courthouse." They said, usually when there's a tax trial goes on, usually the judge will inform us and let us know. And so they contacted the prosecutor and said, "We'd like to do a story on the tax trial that took place on such and such time." And the prosecutor said, "We've got no comment." So they contacted the judge, and he said, "I've got no comment." And they finally come to the defendant. Contacted me and said, "We can't get anything out of anybody else. Would you like to talk to us about your case, your trial?" I said, "Oh, I'm very, very hesitant to do that. It scares me whenever the newspaper comes around, because I've learned over the years that you don't always print what's discussed. You leave out stuff, you take sentences and twist them around, and you usually end up making the defendant look like an ass." And so I'm very hesitant. I said, "I would like to sit down with you, if you give me a few days, and sit down with you and bring some paperwork so that I can show you my thoughts and my beliefs and show you the statutes as to what they read, the way we interpret them, and things of that nature." And I did that. And they really done me a good story. This little newspaper article in the local newspaper circulated around, and ended up, the Springfield paper picked up a story on it, and they done an article. And this circulated quite widespread. central part of Illinois. So many people saw this, and few of them kept it. Later on, there are some other indictments that have been handed down after mine. These people, seeing this article, contacted me, which I in turn put them in contact with the attorney that I used. And he is now furthering the cause with other people. In fact, during my trial, they brought in state people to testify to the numbers, that I supposedly earned. And they talked about my federal obligations, but there was no federal people there. So in these other trials that the attorney's now handling, he brought that issue up in some of the motion hearings, and the judge has said, well, you're correct, that if they're going to enter federal documents, bring up federal testimony, there has to be somebody there from the federal side, in other words, an IRS agent, for example, to testify to a federal liability. Well, in an earlier trial that I was involved with, a trial that took place before mine, we subpoenaed the IRS people to come in. Well, when we issued those subpoenas, they were delivered correctly. The federal government stepped in and filed a motion to remove the subpoena to a federal court, and that was granted. So the subpoena issue was taken to a federal court, and the federal court dismissed that subpoena. In other words, we were then denied to subpoena or bring in IRS officials. The state has now learned that they will be limited, that they cannot. They will not be able to bring in IRS people to testify to a federal liability. In other words, they have now learned, after studying this other case, that if they were to subpoena people in from the IRS to testify in their behalf, that the case would be removed to federal court and the federal court would dismiss those. So we have them in limbo at this moment in time. Those trials have been set on hold until they can iron out, if that ever is possible, to iron out how to get a witness in to testify to a federal obligation or federal liability. And that is one of the first criteria that has to be proven up in a state trial, whether or not you had a federal liability requiring you to do something. I guess that pretty much covers my little story. And again, during break, you'll see me. I'll hand out you some examples of, you can keep them, use them to your benefit as to following the extensions of time and making a record or making a request to extend or assert your Fifth Amendment rights. Okay? Thanks for your time.